Okay, welcome to Advice UK's Eviction webinar. This webinar runs as a single presentation with speech and text. You can pause and continue the presentation at any time, and you can rewind it if you want to hear it again, if you want to check your understanding. There are 3 short exercises in the presentation to test your knowledge before we continue. We'll remind you to pause the presentation, to have a pen and paper ready so you can write down your answers before you continue after the exercises. And the essential information is included in the rent possession guidance document that you can download. It's also got useful resources that you can refer to when you're advising clients in practice. And we're going to run this presentation as a conversation between me supporting an advisor regime to deal with a client. And through that, we're going to be looking at key issues involved in advising a client facing eviction.
Well, thanks for making time for me, Matt. I really don't know what to do. I've got Yasmin, she's a new client, and I've got to phone her for an appointment in 2 hours' time. She phoned me this morning, and I know that, well, let me check my notes. She has nowhere else to go. She has lived at her flat for 3 years. She's 23 and she's a single parent. She works full-time, but is on a very low wage. The council is her landlord, and they took her to court last year when her rent arrears were about £1,000. She didn't want to attend court, so she agreed with her housing officer to pay the rent plus £8 each week for the debt. The court, they made a suspended possession order, and it allowed her to stay at the property as long as she paid the rent plus £8 per week towards the arrears. Since then, she has had other debts to pay, and she's not kept up with the rents, and she thinks she owes around £4,000. What am I going to do?
Okay, well, there's a lot of useful information there. So basically, I'm saying don't panic. And once you've gone through this information we're going to give, you'll understand what can be done, and you'll be in a good position to take things further with your client. So we're going to take a housing first aid approach. And by that, I mean, we're checking if she's at risk of homelessness. And if she is, we look to prevent or delay her homelessness if possible, and then refer her for more specialist help if she needs it. And through what you've already done and the questions you're going to be asking her when you speak again, you'll have useful information you can pass on to whoever's advising her next to be able to take action.
Okay, so what do we need to know so I can help Yasmin?
Okay, well, the general rules for eviction governing tenants are in the Protection from Eviction Act 1977, and we'll run through those first. But then, depending on the type of tenancy that Yasmin has, she may have extra protection in law as a residential tenant. So it's important to be able to work out what sort of tenancy she has, to look at how the rules differ depending on her tenancy and her landlord. And finally, it's important to understand the eviction process so we know what stage we're at and what options are open to the court to stop or delay evictions at those different stages. Bearing in mind you're dealing with Yasmin today, but you could be dealing with a range of tenants in future. And the most common situations you're going to encounter involve dealing with rent arrears, dealing with private sector evictions, but there are also special rules at the moment due to COVID-19 restrictions, which add a bit of delay into the court process, which could benefit your clients. Generally, we talked about housing first aid approach, and in dealing with evictions, I'm suggesting you bear in mind these key principles. We never advise anyone to move out of their home without checking first if they have rights to stay where they are. If the court's got discretion, and we're going to find that out later in the training, then it's possible to stop an eviction until either the tenants choose to leave of their own free will, or they get physically evicted by the court bailiffs. Even if the court has to evict someone, if they have to grant a possession order to their landlord, it's still possible in some cases to delay it for up to 6 weeks if a tenant would suffer exceptional hardship if they're evicted any quicker than that. So even if we can't stop them being evicted, we can still delay the eviction to give them a better chance of finding somewhere else to live, or time for the council to assess their needs and secure accommodation for them. And if someone is threatened with eviction, check if they could be entitled to help from the council if they become homeless.
Wow, okay, well, this is a lot to take in. Can you break this down for me, please?
Yeah, okay, so let's start with the standard rules for all tenants. So we're looking at the Protection from Eviction Act 1977, which explains the general process. It also gives criminal penalties. So if the landlord doesn't follow the rules, they can be prosecuted. It does apply in limited situations if you're not a tenant, but mostly it's applying to tenants. So it's important to work out if you're dealing with a tenant, if you're not sure, or whether they've got some other rights. And the most common other right is a license or permission in law to occupy a property, but without having the same rights as the tenant. So looking at the general rules for tenants first, if you're a tenant, your landlord must first issue a notice to quit or a notice of seeking possession before they can evict you. And under the Protection from Eviction Act, the notice must be for at least 28 days and it must be in writing, unless there's a legal rule that says otherwise. Even after the notice runs out, your landlord cannot just change the locks. They have to apply to court for the court to make a possession order. And even if the court makes a possession order and you haven't moved out, the landlord still cannot evict you without applying to court for the court to enforce that order. And it's court bailiffs that do that, not anyone else. So the landlord cannot just turn up and change locks themselves after getting a possession order. It has to be done by the court bailiffs.
Okay, well, that sounds good, but what can we do if the landlord doesn't follow the rules?
Good question. Local councils can prosecute landlords for following offences. There's two possible offences that may happen if a landlord doesn't follow the rules. Any actions to evict someone without following the correct process are an illegal eviction. So if the landlord got a possession order, but then changed the locks himself, that's an illegal eviction, even though the first part of the process was correct. If the landlord gave notice but never got a possession order and just changed the locks, that's an illegal eviction as well. It doesn't have to mean that the landlord intended to do an illegal action, just that they didn't follow the correct process. And harassment can be done by the landlord or by someone acting on the landlord's behalf, like an estate agent or even a friend of the landlord, to interfere with the tenant's rights to such a degree that they're intimidated out of the property. Doesn't mean they have to be threatened. It could be things like turning off the heating or the water supply. And with harassment, the tenant doesn't have to have left the property for the offence to have occurred. The court would have to be satisfied that the landlord intended the tenant would move out as a result of the actions that are being done. It can be quite hard to prove in practice. But there are also other ways of taking action against the landlord apart from the criminal law. As a tenant, if you have been illegally evicted, you can apply for an injunction through the county court with the help of a solicitor to get back into the property until your landlord does evict you in a legal way. Or if they're harassing you or interfering with your rights as a tenant, you can apply for an injunction to stop that. You can apply for damages if you've been evicted illegally under the Housing Act 1988. And those damages are based on the value of the property itself, minus the value of the property if it still had a tenant living there, which could be less because the new owner might have to take action and spend time and money on evicting someone. So in London, that could be several £1,000s, even for someone with fairly short-term rights as an assured short-hold tenant. But those high damages only apply if there's been an illegal eviction and the landlord is refusing to allow you back in. If the landlord allows you back in, you could still claim for damages, though, for the landlord interfering with your rights of peaceful and quiet enjoyment as a tenant. And it's possible for a rent tribunal to make a rent repayment order, giving you a maximum of 12 months rent repaid by the landlord as compensation. And for any of those things, we'd advise you to contact a specialist housing advisor for more information.
Definitely. I mean, that's really useful to know. But what if my client doesn't have a tenancy? Do they still have any protection?
Okay, well, let's look at some common situations. So if you're an owner-occupier and you've fallen behind on the mortgage, and the court still has the power to adjourn, stay, or suspend any application for a possession order by the mortgage company, and they can suspend an eviction as well. But in mortgage possession cases, I'd say refer your client as soon as possible to a local debt advice service. And not just because the mortgage itself is a debt, but because it's highly likely that your client will owe other debts as well, that may be affecting their ability to pay. Now, if you don't have a tenancy, but you've still got exclusive possession of your home, that means essentially you're the only people living there, you're not sharing with anyone, then the landlord may still need to issue a notice under the Protection from Eviction Act, get a court order, and then have that order enforced by the county court bailiffs. Exclusive possession is a particular legal term that we'll look at when we're defining what a tenancy is in a short while. But there are some licensees that would still have that similar basic protection, even if they don't have additional protection as a residential occupant. Basically, if you're not sure, then get specialist advice. But lastly, if you've got people who are excluded from protection as tenants, you've got other licensees who don't have exclusive possession of the property, the landlord may still need to give notice under any agreement that they've got, or to give reasonable notice in the circumstances. But typically the landlord's not going to need a possession order or need the court bailiffs to arrange an eviction. And common situations which are excluded from even basic protection under the Protection from Eviction Act are people staying in bed and breakfasts or hotels or emergency hostels, or where they're sharing living facilities with their landlord. Like if you're lodging with your landlord, for example, you've got a room in their home.
Okay. Well, how do you actually tell the difference between a tenant and a licensee?
Very important question. To start with, look at what information you've already got. So if Yasmin comes in with any documentation, any letters, if she's got a tenancy agreement, she's got a court summons, or any of the documents to do with her court case, that may say on it if she's got a tenancy and what type of tenancy it is. If you're not sure, you can use the information you've already got and the information you're going to get based on what we say later, and use Shelter's online tenancy checker to help you work out what sort of tenancy it's likely to be. May not be conclusive, but it will be a good starting point. And importantly, the House of Lords, in a case called Street and Mountford in 1985, looked at what makes a tenancy in law. And they look at the totality of the situation. What is the reality of it? So even if your landlord claims that you've got a license and not a tenancy, if all the elements of a tenancy exist in law, according to this court case, then you've got a tenancy, however it's described. And we'll have a look at this now in a bit more detail.
Yeah, because I really want to know what makes a tenancy.
So there's four main elements that make a tenancy. The first one is an odd legal phrase called a term. And that means a period of an agreement. So it could be from week to week or month to month, or you might have an agreement that you can live there for 6 months, which is very common in the private sector, or for a year, or possibly longer. But you've got an identifiable period of the contract. Secondly, are you paying rent? Now, in common law, rent can be doing something in return for being given accommodation. To have statutory protection as a residential tenant, it must involve money changing hands. So either you're paying money to the landlord or money's being paid on your behalf. So if housing benefit is paid directly to the landlord, even though you never see it, that counts as rent being paid. And similarly with universal credit, housing costs paid directly to the landlord. In return for paying rent, the third thing is you have exclusive possession of the property. And that means you've got the right as a tenant or as a group of joint tenants to exclude the landlord or anyone else from the property who doesn't have your permission to be there while your tenancy exists. Now, the landlords do have limited rights to enter your property to check the state of it or to carry out repairs, for example. But your tenancy agreement, if you've got a written agreement, would usually say that your landlord should not unreasonably interfere with your rights of peaceful and quiet enjoyment of the property. And that's an implied condition of any agreement, even if you've got nothing in writing. And fourthly, you and your landlord must intend there's a contract between you. That doesn't mean you've got anything in writing. All it means is essentially that you've agreed with your landlord that you pay rent in return for living at the property. It doesn't mean your landlord was intended giving you a tenancy or any specific tenancy, just that there's an agreement where one side does something in return for the other side doing something. If all four elements exist, then the likelihood is you've got a tenancy in law. And anything you've got in writing will be useful to back it up, but you could have a tenancy in law even if you've got nothing in writing. Now, there are exceptions, and first main one you probably come across it if you're renting privately is if you're living with your landlord. If you share living facilities with your landlord, you've got a resident landlord, they don't have to get a court order to evict you. They just give notice and you have to leave your home. If you've got a non-commercial agreement, and now that could be a family arrangement, for example. Let's say I finish university, I'll go back home. My family lets me carry on living there until I'm able to find somewhere to live on my own. But then I start causing problems. I don't pay for my share of the living expenses. I'm untidy. My parents can just wait till I leave and change the locks so I can't come back in. Or they could just tell me to go, and they could use reasonable force even to get me out of the home. It's assumed that if you're renting from family, it's going to be a non-commercial agreement. Now, there might be exceptions to that. Well, let's say I'm renting a home from my uncle, who's an estate agent. It's his business to rent out homes. I'm renting from him, but he's treating me no differently than he would treat any other tenant. Now, in that case, I might be able to rebut this assumption that this is a non-commercial agreement. But generally, if you're renting from someone close to you, the assumption is it's not going to be for a commercial purpose. So you don't have this residential protection. You're not treated as a tenant. And then in law, there can be statutory exceptions. So a few of those might be if I'm staying in a hostel that's provided for homeless people, if I'm living in university-provided accommodation for me as a student, or if I'm renting a home as a holiday letting. Those are all excluded from protection. So the statutory exceptions will vary depending on what is the tenancy you would normally have if one of those rules doesn't apply to you. And that's why I would suggest using Shelton's tenancy checker. So now we've spelt out what these mean, just in case you want to refer back to it, give you a little time to read it through, or you can pause it and then you can continue.
Okay, that's great. I think I'm going to be using that resource checker a lot. Another question I have is, what if my client hasn't actually paid any money yet, or perhaps they've missed the last rent payment?
Okay, well, what matters is there an agreement that you should pay rent in return for living there? If there is that agreement and you've moved in, you've got a tenancy there, even if you miss rent payments afterwards. That's the main rule.
Great. What if I rent a room and I share a kitchen and bathroom with others who rent their own rooms?
Okay, well, that's relevant for looking at exclusive possession. So if you're renting a room and there are other tenants at the property, each renting their own rooms, and you share, let's say, the living room and the kitchen and the bathroom, you've still possibly got exclusive possession of your own room. And sharing living facilities with other tenants doesn't exclude you from having a tenancy of your room. However, if your landlord is one of those people who's got a room at the property and your landlord is sharing the kitchen, the living room and the bathroom with you, In that case, they count as a resident landlord. So you would then be excluded from protection as a tenant. You may still have a license, you've still got permission to be there. And if you've got an agreement that you're paying rent in return for living there, it's a contractual license. So your landlord should only give you notice to end that agreement in line with whatever you've agreed with the landlord. However, your landlord will not need a court order to evict you if they're living with you. But if you've got possession of a room, even though you're not living there on your own in the whole property, in that case, your landlord does need to get a court order to evict you if they're not living with you.
Okay. Well, say my client doesn't have anything in writing from their landlord. Can they have a contract if they don't have a written tenancy agreement?
Absolutely. So let's have a look at that. For a contract to exist, all that the court needs to be satisfied of is that there's essentially an agreement between you and the landlord that you're paying rent in return for exclusive possession of the property. So letters from your landlord offering you the property and confirming that you're going to pay a certain amount of rent each week or each month, and when your tenancy or your agreement is going to start, that would do, even if you don't have a formal tenancy agreement. Even if you don't have any letters, there might be text conversations on your phone, there might be emails between you and the landlord. And even without that, it's still possible to show that you've got a tenancy of the property. There's two things the court's looking at. One is, are you paying rent? And two, do you have possession of the property? So you can evidence rent payments by regular amounts, at the amount the landlord has agreed with you to pay the rent coming out of your bank account. Your bank statements would provide evidence of that possibly. And even if your landlord has refused to accept, let's say, payment by a standing order, if your bank accounts show that there's a regular amount, the same amount being taken out your bank account to pay your landlord, and you provide a witness statement confirming what's been done and why, then a court could still accept the balance of probabilities that you've been using that money to pay the rent to the landlord. And for exclusive possession of the property, that might be evidence of actually living there. So if you've got bills in your name at the property, or anything else that indicates you're living there, like being on the electoral roll of the property. And for bills, let's say you've got an electric and a gas bill that shows you're using energy consistent with someone living there for the majority of the time. Again, that's backing you up.
Right. I was going to ask about bills and, you know, people taking, you know, money out the cash machine. So that's really good to know. Thank you.
Okay, so those are the four main things. So now, with all of that, you can tell me your answers to these questions before we go ahead, just to make sure that we all understand the basics. So for anyone listening, first question, it's important to know if you're advising a tenant or a licensee, and there are four parts that we've just discussed that make a tenancy according to the judges in Street and Mountford. What are those four parts? And the second question, to evict a tenant under the Protection from Eviction Act, what three things must happen? And lastly, if a landlord commits an illegal eviction, who can prosecute the landlord? So make a note of your answers and then we'll discuss them.
Hi, I'm Roisin. I'm the new advisor that Matt's helping. So, like Matt said, just pause, go through the question. If you need to rewind to remind yourself of what we've been through, that's absolutely fine. Take your time. And when you're ready, no cheating, press play and we'll go through the answers together.
So what four parts make a tenancy, Roisin?
Okay, I'm going to give this a go. So going by the judges in the Street Mountford case, if you have the following, so a contractual agreement to pay rent in return for exclusive possession of your home and for an identifiable term or period, then you've probably got a tenancy.
That is absolutely right. Okay, and remember, there can be exceptions to that you would check, but broadly, if those four elements are present, you've got a tenancy. If any one of those is missing, the chances are that you've probably just got a license to occupy. Okay, and to evict a tenant, what three things must happen?
First, the landlord issues a notice. Then the landlord applies to court for a possession order.
Yep.
And if the tenant still hasn't left when the possession order runs out, the landlord has to apply to court for the court bailiffs to evict that tenant.
Absolutely correct. Okay, if any one of those things is not done, it shouldn't go on to the next stage. And even if the first two things have been done, but then the landlord just changes the locks, that's an illegal eviction. Okay, and who can prosecute landlords for illegal eviction?
The local authority can.
Good. Okay, bear in mind that if an eviction happens out of office hours and you're concerned it may be illegal, or you're concerned when you're advising a tenant, the landlord may act illegally to get someone out, advise your client to contact the police to start with. The police may be able to help a tenant to get reinstated, but any decision on prosecution would usually be left to the local authority. Okay, well, those are the basics.